Hi, my name's Andrew Willinger, and I'm the executive director of the Duke Center for Firearms Law and a lecturing fellow here at the law school. And I'll be your guest host today for this episode of the Duke Law Podcast. In this episode, we're discussing a major Second Amendment case that was just argued before the Supreme Court, United States versus Rahimi. This is the first substantive Second Amendment case to go before the court since its landmark ruling in Bruen just over 1 year ago, last June. And many see Rahimi as a possible opportunity for the court to clarify certain aspects of Bruen's historical test that have divided lower court judges over the past year plus. Joining me here today are Professors Joseph Blocher and Darrell Miller, the faculty co-directors of the Center for Firearms Law and both experts on the Second Amendment and gun regulation. Joseph and Darrell, it's great to have you both on the podcast today.
Thanks for having us.
Great to be here.
So we certainly have a lot to talk about today, and I thought maybe we could lead off with each of us just sharing our general impressions about the oral argument on Tuesday. And happy to start us off there. So for me, at least, one of the interesting aspects of this argument was that there was surprisingly little discussion, at least little detailed discussion, of the actual historical evidence that took up a lot of space in the briefing, and that the Fifth Circuit really focused on in its opinion. So most of the questions that the justices had for the Solicitor General focused instead on sort of broader principles and methodology, other status-based prohibitions, and she didn't really get tough questions, for example, about the specific types of historical evidence the government cited in support of the idea that dangerous people can be disarmed, like newspaper articles and proclamations from around the time of the founding, or about the distinctions that the Fifth Circuit had drawn between various historical laws and the domestic violence restraining order ban that's at issue in this case. And similarly, I thought that Mr. Rahimi's counsel seemed to actually be okay maybe with a broader application of Bruen, right? Even saying that, he thought laws that addressed interpersonal violence generally and banned gun possession would be analogs if they existed. And no justice really seemed to speak up in favor of a narrower interpretation of the Bruen test along the lines of what the Fifth Circuit actually applied. So with that said, Joseph and Darrell, what struck you as sort of surprising or noteworthy about the argument?
I think a lot of what you just said, Andrew, resonates with me. I mean, for those of us who've been writing and thinking about this for, the past few months in the lead up to the oral argument, we've really been, I think, parsing these very specific historical analogs, like what do we make of peace warrants or sureties or these very specific historical examples of legal responses to domestic violence, for example. And that was just like a very small part of the oral argument here. Even looking back to Bruen, which you mentioned, like there, the justices and counsel were kind of parsing things like the Statute of Northampton and these sort of old historical laws. And I just heard very little of that in the oral argument this week. Most of what I heard was kind of consequentialism. The questions were about what will it mean for us in other legal areas if we rule in favor of Rahimi here, like implications for other kinds of gun laws. Rahimi's counsel, you mentioned, like he's really emphasizing like the burden on Rahimi. He kept using the word ban, like.
Yeah, I totally agree with that. And I was really surprised, especially given the nature of the Bruen test, how it's articulated, how it's been briefed, especially in the lower courts. And maybe one way of understanding this is the beginning of the splintering of the coalition in the Bruen case itself. What we might end up getting at the end is a real splintering of whatever short-term coalition on the issue of may issue licensing Thomas was able to pull together for the Bruen decision.
So to me, at least, we talked about consequentialism and sort of these higher level principles that were brought up very frequently at oral argument. And I thought that the justices, for the most part, seemed receptive to the framework that the Solicitor General proposed, the sort of overarching framework for how you would look at prohibited person firearm restrictions. And the idea would be, from what the Solicitor General said at argument and what the government has in its brief, I think that you have sort of two categories. You have one category of people who are not law-abiding, and then one category of people who are not responsible or dangerous. And so the non-law-abiding category, the government seems to be drawing a misdemeanor felony distinction there. We can talk a little bit more about what that might mean in practice and what cases might put pressure on that distinction. But this is a case that deals with the second category, which is people who are not responsible or dangerous and that there's sort of an elevated risk of them having firearms above and beyond the ordinary citizen. And so I think the idea would be that you extract those enduring or overarching principles from the history, and then you sort of see how they cash out in each given case. And we'll play a short clip of the Solicitor General describing this framework now in response to a question from Justice Thomas early on in the oral argument.
General, would you just briefly define what you mean by law-abiding and responsible?
Of course, Justice Thomas. So I would break that into its two constituent components. With respect to those who are not law-abiding, history and tradition shows that that's defined by those who have committed serious crimes, defined by the felony-level punishment that can attach to those crimes. This case focuses on the not responsible citizens principle, and in this context, we think that history and tradition show that it applies to those whose possession of firearms would pose an unusual danger beyond the ordinary citizen with respect to harm to themselves or harm to others.
Following up on that clip, I have sort of a two-part question for you, which is, first, do you agree that a majority of the justices seem to be generally on board with this framework, at least in terms of dangerousness, and at least in terms of the idea that dangerousness and irresponsibility are kind of the same thing? And then, if so, what do you think that might mean for some of these other status-based prohibitions in federal or state law where we've seen conflicting decisions post-Bruen?
Yeah, that's a really good question. And I mean, this is one of the highlights, I think, of the argument, just how well prepared the SG was to sort of engage in these questions. She's obviously had an eye towards the fact that it's not just this particular case of domestic violence restraining orders, but the entire swath of status-based or person-based firearm disabilities. So one way that I understand this passage or this part of the argument is I think the justices are maybe on board in this particular case with understanding dangerousness and irresponsibility as being essentially the same. And I think that the SG would probably count that as a win if that's what she can get from the justices. Where, again, I think we're going to see some severing of opinion amongst the justices is when it comes down to people that aren't law-abiding but aren't otherwise dangerous or irresponsible. So, for example, federal law right now prohibits an undocumented immigrant, for example, from having a firearm. That person is not law-abiding if they're here in the country illegally, but that doesn't necessarily mean they're dangerous or irresponsible. And so I think that that is going to be the real test about what exactly is the status-based or the person-based prohibitors going forward. Is it going to be dangerous and irresponsible plus non-law abiding, or are they just going to require anybody that's non-law abiding to also be dangerous and irresponsible?
Yeah, I agree a lot. I thought the Solicitor General had a just unbelievable argument. I thought she was fantastic. Incredibly well prepared, just as you say, but also just fantastically on her feet, engaging with every hard question. And it was pretty clear that dangerousness was going to be the lead here. And my read was that the justices were very receptive to it. And I think partly because of the facts of this case and the provision that's being challenged kind of make it easy to resolve on those grounds. To take that position did mean disclaiming and walking away from a few other historical principles that might have been useful. Like there's pretty good historical evidence, at least, that lack of virtue could have been a grounds for disarming people. Maybe those principles come back up in another case, but they just, I think, weren't really front and center here. I mean, Darrell, you mentioned the 922G5, the prohibitor that applies to undocumented immigrants. And that's an interesting one because sometimes those people have just committed an administrative violation, not even a violation of the criminal law. And so, whether they're law abiding or not even is a very hard line to draw. I mean, it makes me think, if I can sneak in a question building on Darrell's here, about what really is lurking in the background, I think, as far as the major status prohibitors or person-based prohibitors. Like in federal law, anyway, most of these are nestled together in, as we all know, 18 USC 922G, which then lists a variety of different prohibited classes. The biggest one by far in terms of which is charged most often, the one I think that's on people's minds, is G1, which is often called the felon prohibitor, does a lot more work than G8, which is the one that's at issue here. And at oral argument, it felt to me like there was an interesting kind of back and forth of the SG trying to suggest that maybe that ban is different. The G1 ban has kind of a different basis than the G8 prohibitor. And you even heard a mention of a case which is currently, for the justices to consider whether to grant cert on, a case called Range coming out of the Third Circuit, which involves a person subject to the felon prohibitor, but whose underlying conviction is for a nonviolent, I think not dangerous in any plausible way, felony. So I guess my question for the two of you would be, what do you think about how the court's going to deal with range or just generally with like nonviolent felon disarmament?
Right. So I actually thought there was a very interesting exchange at argument between the Solicitor General and Justice Barrett. Justice Barrett, of course, is the only justice who's really written decisions sort of directly on point in terms of what the historical principle is for disarming certain groups of people. When she was a circuit judge on the Seventh Circuit, she seemed to go sort of all in on dangerousness across the board, not just in this irresponsible category, but that there would also be a requirement that a convicted felon, for example, be dangerous or, be convicted of a dangerous offense. There was an exchange at oral argument where Justice Barrett basically said, well, can't I just say that the principle is dangerousness? Why do we need this non-law abiding exclusion as well? And the Solicitor General it seemed like they were sort of tiptoeing around the issue. And what I took from that was that I think what's most likely to happen here is that the court will probably leave for another day exactly how broad this non-law abiding category is, especially when you start thinking about somebody like Mr. Range, who was convicted of a misdemeanor offense at the state level that's only qualifies for the felon ban based on the prison sentence that could have been imposed, and a very, relatively very minor offense, and has no subsequent criminal history. While 922G8, Rahimi sort of might be in the heartland of dangerousness as the Solicitor General, and I think Justice Barrett said there are certainly going to be these more difficult cases that I think will put a lot of pressure on the non-law abiding category. And one thing to watch for here is there's a cert petition pending in Range right now. I think the government would certainly prefer that the Supreme Court takes another felon case, or at least takes another one together with Range. So it'll be really interesting to see what happens down the road.
Well, one of the interesting things about the argument is, the potential that dangerousness becomes the level of generality that sort of merges different areas that are right now thought of as disparate in Second Amendment jurisprudence, which is dangerous and unusual weapons versus weapons in common use, what can be protected, the whole idea of sensitive places, whether a place is sensitive because of the danger posed there, and then dangerous persons. I think what could be lost, of course, is if the court ends up essentially laminating these three areas with the concept of dangerousness, is there might be other kinds of prohibitions or prohibitors based on other kinds of reasons that basically get lost if dangerousness is the only kind of denominator that we really care about.
So another, I thought, really important piece of the oral argument was that Justice Jackson and Justice Kagan both raised sort of broader methodological questions or concerns with the Bruen test and how that test has worked in practice in the past year plus that these lower courts have actually been applying the historical framework. Justice Jackson, I thought, asked some really pointed questions about how outcome determinative founding era evidence should be, kind of what work going back to the founding era is even doing. And then in one especially illuminating exchange, Justice Kagan asked the Solicitor General if there was any useful guidance that she thought the court should provide to lower courts who are struggling to apply Bruen. We'll play that clip now.
General, there seems to be a fair bit of division and a fair bit of confusion about what Bruen means and what Bruen requires in the lower courts. And I'm wondering if you think that there's any useful guidance in addition to resolving this case, but any useful guidance we can give to lower courts about the methodology that Bruen requires be used and how that applies to cases even outside of this one.
So in response to this question from Justice Kagan, the Solicitor General identified three major issues that she said it was important to provide guidance on. So first, she said there's this fact that lower court judges seem often to be laser focused on enacted regulations over other types of historical sources or evidence. Second, she identified the level of generality that some judges are using to assess history and said that, in some cases, courts have basically been using such a narrow level of generality that they're effectively requiring a historical twin or a historical regulation that looks exactly like the modern law, which Bruen says is not required. And then third, she said that lower courts in some instances, are placing dispositive or nearly dispositive weight on the absence of historical regulation or historical silences, which, of course, might be due to any number of reasons beyond a constitutional or Second Amendment concern. What I'm curious about and would love to hear your thoughts on is how do you see these broader issues that the Solicitor General identified potentially influencing or appearing in the opinion in Rahimi? Do you think it's more likely that this will come in the majority opinion, maybe that some group of justices will concur to say something about the Bruen application problems? And then finally, as I mentioned earlier, were you a little bit surprised that no justice really seemed to push back on any of these concerns and say, well, actually, Bruen requires a pretty narrow analysis?
Yeah, I mean, to start with Justice Jackson, because I also thought that was really fascinating to see, and I guess we should emphasize Justice Jackson joined the court since Bruen, having replaced Justice Breyer. So this is really our first chance to see her in a Second Amendment oral argument. She seemed to be the sort of high watermark in terms of pushing back on Bruen as a framework. Like, in other words, it seemed that she's not inclined to normalize Bruen as the test, which really did make me wonder, if this case goes as, and we can talk about this more, as I expect it to go and the government to win, whether she may be joined by the remaining Bruen dissenters, that is Kagan and Sotomayor, would enter a concurrence, essentially saying, look, the government wins this under the Bruen test as articulated, but here's why that test is problematic because of what it requires us to do to the historical record and so on. Or do they just sort of keep their powder dry, join with the majority, take the win, and move on? In terms of the majority opinion and what, we can expect or hope for in terms of guidance from the court, I mean, like going into this, my hope has been that we get something sort of like what's often called the exceptions paragraph in Heller, where the court said nothing in our opinion here should be taken to cast doubt on such longstanding prohibitions as, and then it lists off some things like prohibitions on felons, the mentally ill, dangerous and unusual weapons, sensitive places, none of which were actually directly before the court in Heller. So there's at least an argument that that whole paragraph is dicta, but it was the basis for most, I mean, empirically speaking, most post-Heller Second Amendment litigation, even if it was dicta. So maybe in Rahimi we get something similar. I mean, the SG's answers there about, not just focusing on regulations, but the broader historical context, using the right level of generality, not overreading the silences. I agree with all of those. They're things that Darrell and I and others have written about. I should say, full disclosure, there's something we address in our amicus brief that we filed in this case in support of the government. But I'll be interested to see how the court addresses it, because it's a tough thing to put words to. Here's what the right level of generality should be. Like, it doesn't come with an obvious metric.
I totally agree with all of that. And just to be clear, we filed that amicus brief with some other scholars outside at Duke in our individual capacity, not on behalf of the center, which doesn't take positions in litigation. I think the worst outcome in some ways may be what you were sort of gesturing to, which is, imagine a 4-3-2 split or a 4-4-1 split, where you essentially have a plurality of justices playing small ball, right? Just for this ride only, but not giving the big kind of guidance to the lower courts about how to do the Bruen test, how to do analogy, how to do this sort of traditionalist approach. And then another, 3 or 4 justices essentially, swing for the fences, giving a lot of guidance, and then one dissenter. And then you're in the world of not knowing exactly what the law is, and every intermediate appellate court gets to pull from the plurality what they wish. One panel says this was a really narrow opinion on this topic. The other panel says, no, I'm following the plurality that's giving guidance. And that's not that helpful, I think, for clarifying the field in the way that would be useful to lower courts.
One thing that makes me think of, I mean, it sort of calls back what you mentioned earlier, Darrell, about the concurrences in Bruen, which I sometimes wonder if they get as much attention as they really do deserve. Because, Bruen on the one hand is not a close case. It's a 6-3. But then there are these concurring opinions, and the ones that stand out the most to me are the two you mentioned, Justice Alito writing for himself and Justice Kavanaugh joined by the Chief Justice, who echo a lot of what the court said in Heller. I mean, in Kavanaugh's opinion, literally cutting and pasting the text from Heller and McDonald, which says, again, emphasizing all kinds of gun regulations might be presumptively constitutional. Those 3 justices, Alito, Kavanaugh, and the Chief Justice, are in the majority in Bruen, but are they really, like, in their hearts of hearts, if they're entering those kinds of concurrences? And it may be that Rahimi kind of sees the split, and if some of those justices go along with the 3 justices who dissented in Bruen, subbing in Jackson for Breyer, I mean, you get a majority just there, even independent of what the other justices do. It'd really be fascinating to see how that goes.
Yeah, and just to add on briefly there, I mean, it does seem to me like if there is some group of justices that chooses to write, whether it's a concurrence or a dissent, that talks about broader methodological issues with Bruen, that sort of creates a situation where any justice who feels differently is going to try to respond. So you might really get a very splintered array of decisions with differing guidance on Bruen, which wouldn't necessarily be very helpful to the lower courts. Sticking with Justice Jackson for just a minute, she raised some questions. I mean, I talked about she raised these sort of broader methodological questions about Bruen. She also had some questions about the government's preferred approach to these prohibited persons laws would actually work. And in response, the Solicitor General, I understood her to be basically saying that once you derive an overarching historical principle about what groups can be disarmed, the question then becomes whether the legislature, with respect to any particular category, has appropriately deemed certain individuals to be dangerous. And so Justice Jackson had questions about what does this actually look like and how much deference is there to the legislature under this view. So I was wondering if you had any thoughts on that, and I guess specifically how empirical you think this question is.
So that second part of the question on the empirics, I'll leave for Darrell because he's written and thought a lot about this sort of the continuing relevance of empirical data even after Bruen, even under the sort of narrowest version of Bruen. But I would say that who gets to make the first move in defining which group or which people are dangerous is going to be the big question in Rahimi, because I don't expect, again, just preview of coming attractions here, bottom line, I don't think Rahimi is going to win this case. I think the U.S. government's going to win this case. But there's a lot of different ways to win. And if you're a legislator, you care a lot about the sort of breadth of the holding. What the SG wants, and what I think at least initially makes a lot of sense, is that the legislature gets the first crack at defining the breadth of the group that is dangerous, right? And of course, like any legal prohibition, it's going to be inevitably somewhat overbroad, somewhat underbroad. But that's in the first instance, at least for the lawmaking process, to decide. And I would think that legislatures, just as they did historically, should get a fair bit of deference on that. I mean, the historical laws that the briefs at least are fighting about, even though they didn't come up in oral argument that much, aren't, for the most part, individualized determinations. I mean, some of them, surety laws, maybe peace warrants might have been, but a lot of these are just broad class-based prohibitions that, even under Bruen's test, seem to get deference. So I would assume that same kind of thing needs to come along for the modern legislatures as well.
I mean, it was really a fascinating interchange in the oral argument because I think it highlighted something that people don't think about, which is when you have these sort of constitutional tests that the Supreme Court articulates, especially these historical ones, obviously it pushes down into the lower courts, also push down to the legislature. Do they actually have to amass a record on historical information, which is something that they're not really good at doing. And so I think that, one possibility, as you mentioned, is that we'll get a sort of higher level of generality, who's dangerous, but no requirement that the kind of dangerousness be the same kind of dangerousness that existed in 1791 when the Second Amendment was ratified, or 1868, when the 14th Amendment is ratified. But instead, the principle is dangerousness, and then the legislatures are in a better position to sort of populate why they're designating somebody dangerous with modern sort of criminological data or empirical data. It's not repudiating Bruen, it's just operating within the Bruen framework.
So switching gears a little bit, one thing that came up at oral argument a few times is this issue of facially discriminatory historical gun regulations and sort of how to deal with those within a text, history, and tradition test. In Rahimi, the government had, I believe, initially relied on some of these discriminatory laws at the appellate court level, but then disclaimed any reliance at the Supreme Court, with the Solicitor General, I think, suggesting that, these laws could still be relevant if we're talking about restrictions today that ban people who are outside of the political community from possessing guns. If you think about people like unauthorized immigrants, but in general, they wouldn't be relevant in a case like this, where we're talking about domestic violence restraining order respondent who's not excluded from the political community as a general matter. And in her questions to Mr. Rahimi's attorney, Justice Jackson said that she was troubled by the idea of having a history and tradition test if it requires some sort of culling of the history so that only certain people's history actually counts. So do you see the court ultimately doing anything with this issue in its opinion, trying to tackle this question, which some lower courts have really been wrestling with, about what do we do with these laws from the historical record that are discriminatory?
Yeah, it's a really, really fascinating and puzzling question about what to do with essentially racist regulations or regulations that are applied in sort of a racist fashion or have racist motivations, and what to make of that phenomena, that historical reality today. Justice Jackson was clearly incredibly skeptical of the entire enterprise that Bruen has set out, and this is probably the sort of the weakest part of a historical test, which is you end up potentially have to import a lot of really, as our erstwhile colleague said, sort of sordid history to figure out what the laws are. So I can imagine a court essentially sort of working around this problem by saying, look, the principle is pretty broad. The fact that in the past people used really noxious kinds of heuristics to figure out who's dangerousness, like race, is just not part of it. But the principle called dangerousness is quite significant. And so even using some of these sort of sordid sources, you can get a principle that is not sort of as besmirched by sort of racist ideology to say, look, there's some things that we can agree on, that dangerous persons shouldn't have guns, that persons that are potentially not law-abiding should have some sort of restrictions, these kinds of things that we can all agree on. And the fact that in 1791 they had a different idea about, who fell in that category and who didn't, not based on empirics or science, but based on prejudice, is sort of beside the point.
Yeah, I mean, I think if Justice Jackson does end up writing a concurrence, this could be one of the themes of like just the difficulty of doing this kind of cutting and trimming. But I guess I would not expect the majority, if it ends up being a cohesive sort of, say, 6, maybe even 7 justice majority, to really tackle the problem, because for all the reasons that Darrell just gave, it's just so big and so hard. And it's not specifically a Bruen problem. I mean, this kind of thing comes up in all the areas of constitutional law where the court is adopting these sort of historical tests. Lots of critics of Dobbs, for example, raised, the question of like, what exactly, whose history are we looking to here? And I think it's probably just too much to chew in a case where they don't really have to.
I mean, you look in old sort of criminal law books, going back hundreds of years, there's always some kind of special penalties for African Americans, for example, committing crimes. It's not that you read that and therefore say that robbery or assault or something else shouldn't be a crime. It's that you shouldn't actually have a crime that makes, express differences on the basis of race. And I mean, that's the kind of logic, I think, that would uphold this kind of reasoning, which is, you're not trying to say that crime is good or crime shouldn't be abolished, but what you're trying to say is that criminal law should be applied in an equitable fashion. And so we can basically hive off the inequitable aspects of the historical record.
And I can't help but just plug 2 pieces of work here. One, Darrell, that you mentioned earlier in reference to our erstwhile colleague, Jake Charles, now of Pepperdine Law School, has a fantastic article in the Stanford Law Review online called On Sordid Sources about this exact problem. The second, actually, Andrew, is yours. Andrew has a forthcoming piece on Bruen's enforcement puzzle, which is a deep dive into the enforcement of a facially neutral gun law, actually in a southern state in the late 1800s.
So I'm going to ask a question, which is, the Solicitor General drew a connection between the principle of being able to disarm non-law-abiding and irresponsible and dangerous people to locational and class of arms restrictions, suggesting that a similar dangerousness principle animates these type of laws, kind of like what I mentioned before. And we'll play a short clip from that portion of the argument.
And again, I would draw the analogy to sensitive places and to dangerous and unusual weapons. In each of these contexts, the court is trying to identify those arms that are especially dangerous, those places where carrying weapons will pose unique dangers, and those categories of people who, beyond the ordinary citizen, possess a particular danger if they have access to firearms.
Do you find that line of argument convincing? And if so, what do you think it signals for future developments in class of arms and sensitive places locations in the years to come, if in fact dangerousness is the lodestar for these kinds of issues?
You mentioned this in response to an earlier question, Darrell, about dangerousness sort of being the principle which, based on this argument, seems to be the terrain the government's choosing to argue not just the 922G person prohibitors, but also class of arms cases. We've got some of those bubbling up. Sensitive places, and this came up repeatedly, exactly, as we heard from that clip. My own sense is that actually it would be unfortunate if dangerousness is taken to be the only basis on which a place could be declared sensitive. That would mark actually a pretty significant narrowing of how that concept has been understood thus far, and not just by courts and not just by you and I who've written about this, but people with broader views probably of gun rights than either you or I hold. Eugene Volok's a good example here, who say that sensitive places can be those places both where there's an increased risk of danger, but also where the government is acting as a proprietor, right? And that's not treating guns as a second-class right. A Second Amendment is a second-class right. That's how First Amendment doctrine works, right? The government has enormous power in regulating speech over property that it owns. And so I would hope at least that if dangerousness is treated as a sufficient principle, it's not treated as a necessary one. There should be other principles here that can do work, even if in the person-based prohibitors, dangerousness ends up being the lodestar.
So I think first, this is another area where I really was impressed with the Solicitor General, right? Because I think clearly the government has kind of a cohesive theory of, looking not just in the prohibited persons context, but trying to sort of shape doctrine outside of that as well. And she clearly had that in mind in some of her responses to the justices' questions, and I think did a really good job trying to tie these different categories together. I do share some of your concerns, Joseph, about the idea that dangerousness would be the only sort of irrelevant principle for deeming a location sensitive. But I think at least this would be sort of a move in the right direction when you think about some of the major sensitive places litigation that's been happening, and where you're really seeing district courts especially sort of requiring a comparison of the specific location today versus the specific location in the founding era, right? Things like zoos or parks, right? And not really doing any analysis of what the underlying reason is for banning guns in these places. So I think if there's any movement to an approach that actually allows for more consideration of what the underlying principle is, what's driving the legislative judgment for banning guns, I think that's going to be an improvement.
So I'm going to be a little bit of a contrarian in this sense, which is I'm a little worried, actually, if dangerousness is the lodestar for this reason, because dangerousness is the very reason that people want to carry guns in these places, right? The whole principle is the gun rights advocates in particular, their philosophy is like place where guns aren't are the places where they most need to be. And so I'm a little bit worried that if the dangerousness just sort of unmediated becomes the lodestar for sensitive places doctrine, it's going to feed into this sort of argument that either the government or a private party has to supply some kind of security apparatus, or you get to take your gun there and sort of serve as a deterrent. And there might be all kinds of other reasons why somebody wouldn't want guns in a sensitive place, not having to do necessarily with personal safety, a Quaker meeting, for example, or, a pacifist.
So Justice Gorsuch asked what I thought was a pretty interesting question at the oral argument about basically whether the level of generality should be sort of calibrated equally for both the rights side and the regulation side in Second Amendment cases. And I know that's something that both of you have been writing and thinking a little bit about, so I just wanted to maybe give you a chance to comment and unpack that a little bit. And we can play the clip now from Justice Gorsuch's exchange with the Solicitor General.
And you're saying we should overlook that. In the same way, I think you would say, I want to make sure you'd say, the analysis also applies similarly to the right side of the ledger, the regulation side and the right side. We're not looking for, is it a Fowler or is it a musket? Is that a fair understanding of how you see the law?
Yes, we think that it applies in both directions, both in understanding the right itself and in understanding the limitations that are built into that right.
Okay. I think this is one of the things, actually, that Darrell and I emphasized in the brief that we filed along with some other scholars, again, independent of the center. It's something we've all been writing and thinking about ever since Bruen, because Bruen's test just introduces all kinds of levels of generality problems in terms of how you read the history, how you frame the rights claim, how do you frame the regulation. I think the Solicitor General's answer here, frankly, is exactly the right one. What you can't do is asymmetrically define the right very broadly and the regulatory history very narrowly, or, and this is what I think Justice Gorsuch was pointing out, vice versa. Like if you're going to pitch one at some particular level of generality, say it's broad, then the other one needs to be the same, or else you get kind of a one-way ratchet in favor of either rights or regulation. Now, again, it's hard to articulate because there's not like a metric to say, here's what the level of generality is. Like it's hard to measure, but I think you can say, look, we're going to say that, for example, the modern AR-15 is relevantly similar to a black powder musket from 1791. They are in some ways, and in some ways they are very much not relevantly similar. Well, then we need to be similarly either tight or forgiving in terms of how we frame the sort of accompanying regulation.
I think there's actually two really interesting other issues with respect to the sort of level of generality. The one is that there's a way of sort of articulating it in the originalist frame, which is, if you remember in Bruen, Justice Thomas says, there's a sort of balance that was struck at the founding, and you can't sort of rebalance the right with sort of open-ended sort of balancing test. That's why Bruen rejects what had come before. So symmetrical analogs or symmetrical levels of generality is one way to maintain, right, a balance that was set at the founding. But that leads to another question that I don't think a lot of people have really thought about or have an answer for, which is what is that balance? What is the time zero distribution of ability to use force? And so sort of balancing, I think, needs to be symmetrical, but symmetrical to achieve, what status quo ante, I think, is the question that no case has yet answered well.
So speaking of questions that are hard to answer, I want to zero in on a moment from oral argument here where Rahimi's counsel, public defender Matthew Wright, got a tough question from the Chief Justice. This is one that got a lot of attention in the public coverage of Rahimi, so why don't we just quickly listen to the clip?
Well, to the extent that's pertinent, you don't have any doubt that your client's a dangerous person, do you?
Your Honor, I would want to know what dangerous person means. At the moment,
someone who's shooting, at people, that's a good start.
That's fair.
So this is a tough one, and we've talked a lot about how excellent the Solicitor General's argument was. I think there's general agreement about that. I will say from my own view, I think the public defender had a really tough argument to make and got a lot of tough questions from the justices, including that one from Chief Justice Roberts. And I just wonder what y'all think about how he handled it, either that exchange or just more generally. Like, can you, as Rahimi's counsel, concede that your client is dangerous and still win this case? Or was that a fatal concession?
I think he handled it about as well as he could have. I don't know how you can say that Rahimi is not dangerous. But honestly, I thought that Matthew Wright did a pretty good job trying to sort of steer the focus to just the aspect of this being a total ban on possession, right? In the home, outside the home. And he kept saying some version of, look, there's just no history of a complete ban on gun possession by someone who is a constitutional rights holder. I think that's probably the strongest argument to make. I think he did a pretty good job putting the focus on that. It just didn't seem to me, honestly, like the justices were buying it. Maybe the thought is that that's just too sort of narrow of a slicing of the history under Bruen, right? If the only thing that distinguishes this law from other, historical laws that might have been dangerousness based is the scope of the punishment. And I also thought that, the justices threw a lot of very difficult hypotheticals at Mr. Wright. And I thought that they just weren't maybe satisfied with his effort to sort of say, look, you can find in favor of my client while not necessarily going down the slope of having all of these other groups also possessing guns, like the mentally ill, for example.
One interesting thing about that is I think it just reinforces the strange consequentialist nature of the oral argument. You would think that, you could just lean into the principle that, there's no comparable kind of regulation historically. And if you want to do constitutional law in, a post-Bruen world, the way it breaks is just the way it breaks. And that's the consequences of having constitutional rights. But the fact that no one seemed to be willing to sort of grasp that nettle, I think, was quite revealing about the nature of the concerns and maybe in some ways the softness of the Bruen test itself.
There were some questions that came up at oral argument about the due process that is available or accorded to respondents within the state protective order proceedings, including that perhaps it's difficult to challenge a protective order that might be issued improperly or without an actual finding of dangerousness. Some discussion about, whether that could be challenged in federal court or whether it could only be challenged in state court. And also some concerns raised specifically by Justices Thomas and Alito about the length of these protective orders, whether in some states they might remain in place as a default for a long period of time. So do you expect these due process arguments, they're outside the Second Amendment context, right? But do you expect them to surface at all in the opinions or the dissents in this case? And how do you think the fact that this is a facial challenge rather than an as-applied challenge might affect that?
So I don't expect it to surface at least in a majority opinion. It's true that Justices Alito and to some degree Thomas sort of surfaced these concerns, but then there was this remarkable moment. I think it was just after Justice Alito's comments when Justice Sotomayor asked, just to clarify, none of that is actually before us here. And you can't hear nodding, of course, in the oral argument, but then later questions from Justice Gorsuch and Justice Kavanaugh seem to suggest to me, at least, that there's not an appetite to tackle that. Again, as you say, it wasn't actually argued, but it's not the question on which the court granted cert. It's not the main, theme in this case. It was a huge theme of the amicus briefing, which I think is interesting, that of the briefs filed in support of Rahimi, I would say many, if not most, were making what were effectively due process arguments. And I just did not get a sense that the justices really wanted to take that on or need to take that on here. Maybe if Justices Alito and or Thomas enter opinions, they could even be concurrences, but if they enter separate opinions in this case, maybe they would flag those kinds of concerns. But, and just answer the question about facial versus as-applied challenges, I mean, this is a particularly awkward case, I think, in which to raise the due process concern, because Zacky Rahimi did have what looks like a lot of process, consented to this order, had notice of it. I think it was in his possession, actually, when the government, when he was investigated and found to be in possession of the gun. So, an as-applied challenge means you're saying this was unconstitutional as applied to me, and it's hard to see for me the due process claim here.
We've sort of touched on this briefly already at several points, our thoughts about how the ultimate decision in this case might look, the opinions might look like in terms of the majority and any dissents. But I thought it might make sense for us to conclude with specific predictions for how the court's going to rule and what the sort of lineup will be, recognizing, of course, that that's always a very difficult thing to predict based solely on the oral argument. I see this as probably a 7-2 decision. It would not surprise me at all if Justice Barrett writes the opinion, given her past opinion focusing on this dangerousness idea. And I think that that's probably the direction the court's going to go, the majority is going to go, is to say that all we need to decide here is that dangerousness is a historically supported principle and Rahimi is dangerous, and 922G8 is sort of the heartland of dangerousness, at least as it's applied to Rahimi, and that's it, and not sort of go into the law-abiding aspect. I think Justices Thomas and Alito would be in the dissent, and that you might see, as we've talked about briefly, a concurrence from Justice Jackson, Justice Kagan, maybe some combination on the methodology and on these sort of broader questions. And it could be Justice Jackson because, as I think you mentioned, Joseph, she's really bringing a fresh set of eyes to this Bruen test. She was not on the court for Bruen.
I think it might even be 8-1 with Thomas dissenting. And then again, as you sort of mentioned, the question is like, what does the concurrences look like, especially if we get a majority opinion that tends to be really tailored very narrowly? Is this going to be an opportunity for Justice Jackson to essentially offer guidance that's not being offered in the majority opinion to lower courts of applying the Bruen test, throughout the Second Amendment doctrine?
I'm happy to go last here because that'll make it easier to edit this so that we can, after the opinion comes out, put me saying whatever actually. Depending on how the opinion writes, I mean, I think there's a way to write this. Since we have a 7-2 and an 8-1, I should take like the high bid and say unanimous. That's hard for me to get there, but you could write an opinion here like the court did in its Caetano decision, which is essentially a per curiam, essentially saying what the court had done in that case. This is a post-Heller case involving the constitutionality of a prohibition on stun guns. The court just sent that one right back down and said, okay, not that. We're not going to give a whole much more guidance, but what you just did there was wrong. In that case, it was the Massachusetts Supreme Judicial Court. It seems unlikely they would do that for the Fifth Circuit, and there was enough discussion, probably unlikely. But, I think a narrow opinion that doesn't walk back Bruen and doesn't make Justice Thomas feel like he has to defend it too much could maybe get an 8-1. Even a 9-0. But it feels to me pretty confident the government wins here. I think 7-2 is probably the safe money bet.
Well, with that, thank you so much for joining us on this episode of the Duke Law Podcast. You can find the Duke Center for Firearms Law, including our Second Thoughts blog, where we've been tracking developments in Rahimi, and we'll continue to do so up until the expected opinion in the case next spring, on the web at firearmslaw.duke.edu. And you can also follow the center on X, the platform formerly known as Twitter, at Duke Firearms Law. And if you haven't already, please be sure to follow the Duke Law Podcast on Apple Podcasts or wherever you listen to your podcasts. Until next time, go Duke.